Hello, we're going to deal with some difficult questions, but that I think people need to know the answer to, particularly if you or a family member are facing these questions. So I have 4 questions that we'll go through today. The first is, can a person be found guilty of a rape when there is no force or threat of force alleged? The second question is, it goes without saying that you could be convicted of a rape if the alleged victim was a particularly promiscuous woman or man, even if the alleged victim were a prostitute. It would be possible to be found guilty of rape. But the question is, will that give you a better chance of being found not guilty? And so I think we should discuss that. People come to me with situations where they say, well, this woman was well known in the community, or this woman slept with half the people in my workplace, or half the people in this bar that everybody goes to, or something like that, or half the people in the dormitory. So we will discuss, and I'll answer for you. I'll answer the question of whether that actually helps your defense if you would be accused of a sexual assault. The third question, and this comes up a lot, is what if there is no medical evidence? And I'm talking an allegation of rape, and there is no medical genital evidence that will come from what used to be called a rape kit, is now called a sex offense examination. In that situation, very often there will not be any medical evidence. So what does that mean? And does that mean that you're automatically not guilty? It certainly doesn't. But I'll explain how we deal with that. The fourth thing that comes up quite often is people will tell me that this alleged victim changed her story many times, or even that she said that it did not happen, or a legally difficult, complex issue that sometimes arises is that it happened, but it didn't happen with me. It happened with another person. So if she displays behaviors or even makes statements that say that this didn't happen, I will discuss with you. It certainly doesn't mean that you're automatically not guilty because of that. I'll explain to you how we deal with that. Now, my name is Joseph Hudak, and I'm a lawyer in Pennsylvania. I do cases in all states, but that's typically done with in conjunction with your local counsel. I feel that here in Pennsylvania we've got a handful of lawyers who are exceptionally effective in these kinds of cases. But something that I'd emphasize, there's a lot of good criminal defense lawyers, but for these kinds of cases, it's good to have a lawyer who has a great deal of experience, and particularly dealing with some of the very technical problems that comes up in these kinds of cases that doesn't come up in other cases. I've done dozens of murder cases, hundreds of drug cases, all sorts of cases like that, but these fit almost into a special class. And so I am going to answer those 4 questions for you, but I think it's better for us to understand if we start with the beginning of a sex offense case. Now, in a future video, I'm going to explain the preliminary stages, because things need to be talked about in regard to how you get bailed out, how you get arrested, what kind of publicity there is. And there's also an important procedure that's called a preliminary hearing, but we're not going to discuss that today. we're going to assume that you went through your preliminary hearing, your initial screening of the validity of the charges, and you're now facing actual criminal charges, felony charges, in a courthouse. So if we were proceeding to trial on a case like this, the first step that would take place would be the jury selection. And obviously everybody knows that's a critically important thing. Now, in a future video, I will explain my particular techniques and strategies for selecting a jury. And indeed, there's special strategies for selecting a jury in this kind of a case. But what I want to talk about today is a jury instruction question that has become very widespread, and it is highly problematic. Now, in a sex offense case, in recent years, there has developed a legal theory. I mean, it always existed, but it has been highlighted in recent years. And that is, and they emphasize this both at the beginning and at the end of the case, they emphasize to the jury that you as a jury are permitted to find this person guilty based on the uncorroborated testimony of the alleged victim. So the reason I say that's problematic is essentially they're emphasizing that you can find the defendant guilty only because the alleged victim said it, nothing else. That there's no medical evidence, there's no witnesses, there's no DNA evidence. None of that is required. And in fact, I, as a defense lawyer, obviously will argue all the time that the absence of those things, like medical evidence or DNA evidence, is proof that the defendant is not guilty. But the court will emphasize that the jury is allowed to find a person guilty with the complete absence of all of that type of evidence. They can find you guilty only because the alleged victim said that you're guilty, nothing else. Now, how do they do that? There's a procedure before your trial starts where you select the jury. And sometimes that can be a very expansive procedure and take days, but in most cases that will take about 1 day to do. And that will typically take place in a courtroom, and you will accompany me as your defense lawyer, and then the prosecuting attorney and maybe an assistant and a court clerk, or sometimes the judge, will all sit at a big conference table in the front of a large room. It's sort of like a courtroom. And there will be hundreds of potential jurors in that room. Now, they will randomly line up 49 jurors to start, typically 7 rows and 7 people. And the reason is because ultimately what you're going to end up with is 12 people on a jury. 12 Angry Men is the famous movie. There's 12 people on a jury, but today they typically pick 2 alternates in case one of those jurors becomes sick or has a personal emergency during the trial. Sometimes, if it's going to be a lengthy trial, they'll pick 4 alternates or even 6 alternates. But let's say in a typical case, we're going to pick 14 jurors, and that will take about a day. Now, in Pennsylvania, there is a list of 16 jury questions that have been approved by the courts, and they're used in every case, whether you're in Philadelphia or whether you're in Pittsburgh or Harrisburg. These same 16 questions are always used, and they actually give you quite a lot of information about the thinking and the attitude. There's background information also, and you want to know the area that you're picking this jury from, because you can tell a lot about the people by the area that they lived in, the area they grew up in, the area that they live in, where they went to school, how they're employed, what their children do, what their wife does, or what their husband does. So you're getting a lot of information from these standard 16 questions. And these standard 16 questions are used in thousands of cases: murder cases, drug cases, robbery cases. They all use the same 16 questions. But in a sex offense case, the prosecution will always add, or ask the court to add, and the judge will almost always agree to add a question. And that question will be, would you be able to find this defendant guilty? And the defendant's sitting there right next to me. We're interviewing the jurors one by one. They'll say to each juror, as you bring them up to the table, would you be able to find this person guilty based solely on the uncorroborated testimony of the alleged victim? No other evidence. Would you be able to do that? So, I mean, it's pretty horrifying to go through that, because it's sort of planting the idea in the minds of each one of these jurors, and doing it before the trial even begins. You're sort of planting in their mind, hey, if she said he's guilty, then he is guilty. And if the person answers no to that question, they typically will be discharged from the jury. They won't even be on your jury. So, they're really stacking and pre-programming the jury. Now, there's lots of ways to deal with that, and we'll talk about that in a future podcast. In fact, a good way, and I'll give you just one of many ways that you can deal with that. You can ask the court to give the instruction, and most judges will, to each juror, would you be able to find this defendant not guilty solely because he took the witness stand and told you he was not guilty? Or would you be able to find this defendant not guilty? He's not even taking the witness stand. He's not even taking the witness stand. But many people from the community are going to explain his reputation to you. Would you be able to find him not guilty based solely on his good reputation? And those are equally valid and equally strong points of law in the way that these trials are conducted. We have all sorts of rules that decide, what evidence can be used to prove what or to disprove something else. That is an equally valid and equally respected, strong rule, that you could find a person not guilty based solely on that. If you wanted to push it farther, and I don't want to get carried away because I could probably do an entire video just on this, you could also start asking jurors, do you know, and would you be able to find a defendant not guilty if he presented absolutely zero evidence? If he just stood up at the conclusion of the prosecution's case and said, I just don't think they proved their case beyond a reasonable doubt. I'm not even going to bother to present a single witness or a single piece of evidence. So let's ask the jurors one by one, would you be able to find the person not guilty on that basis? So there's numerous more procedures that we can use to counteract that jury question and the brainwashing and pre-programming that jury question creates. But I'll have to do a separate podcast on that and on a couple other issues that we could really talk about them at length. Now, when this jury selection begins, they will read the charges to the jury pool. And this is a horrible experience, absolutely horrible, because they're going to read what the allegations in the case are in some detail. And out of those 49 people, half of them are going to be so emotionally distraught just after hearing the charges that they're going to ask to be excused from this jury for this case. So, we have to deal with that. I've had some judges in generally outlying counties, not in Philadelphia or Pittsburgh, but I've had some judges just give a short, brief description of the nature of the case. For instance, to say, in this case, this defendant has been accused of sexual offenses, and you will hear evidence about that. Sometimes they'll just say that, but in counties where they actually read the charges, and by the way, a lot of times in this kind of a case, you could have a count one rape, and you may have a dozen additional lesser but related charges all in that same case. And believe me, by the time that the jury is done hearing that, they're very emotionally distraught. But we do have ways to counter that, and I'll explain that in the future. All right. Now, as to the questions that I asked here at the beginning, I said, could you be found guilty of a rape if there was not even an allegation of force or threat of force? Well, that's typically how, for decades, people thought of rape. They thought that there was some kind of extremely violent force involved. But as of the last decade or so, that does not have to be. And this is probably for the good. But let me tell you, in Pennsylvania, what the actual jury instructions say in regard to force. And this is out of the instruction that at the end of the trial, the judge is going to read this to the jury and tell them, here's the definition of each of these charges that this person has been accused of. Now, long ago, this used to say, that there was sexual intercourse by force or threat of force. And now, here's what the jury instruction says. It says, the force used or threatened, okay, so you either use force or threaten force, can be physical force or violence, but it does not have to be. It is legally possible for an individual to commit rape by using threatening intellectual, moral, emotional, or psychological force. Now, we will get to that later because I said we're going to talk about a situation where the alleged victim's behavior would tend to make you think that the allegation, the assault, did not take place. Sometimes people just don't act as if they've been assaulted. And sometimes that makes a jury think that they, in fact, were not assaulted. But in these kinds of cases, they have experts who will testify essentially that almost anything that a person does is okay. It cannot be used to show that the assault did not take place. A pretty widely used book is titled Predictably Irrational. And so you'll have experts come in and say, even if this alleged victim took back her statement and said that it didn't happen, they'll still prosecute. And they will have an expert come in and say, yes, that's quite common for a victim to change the story, to totally take back the story, all these things. So there does not have to be force or threat of force. And I did say that we'd discuss this more when we talk about the behavior expert. That would be the final question I'm going to answer. If you don't have evidence of a victim's behavior that would seem to suggest that the person was assaulted, does that help your case? Well, of course it helps your case, but they're going to call an expert to try to say that it doesn't help your case. I think the experts might take it too far. Again, what that jury instruction said is that a person could commit the crime of rape by using or threatening intellectual, moral, emotional, or psychological force. Now, I think a common example might be the scandal with Catholic priests. That might be using some sort of superiority, moral superiority, or religious superiority. The priest is in a very strong position over the altar boys, for God's sake. That would certainly fall in that definition. Also, the famous Harvey Weinstein case. I follow that pretty closely. A person is the most powerful producer. He can make or break the career of an aspiring actress. And I know now actresses are called actors, and I support that. I think there's a good reason for that. But he rarely, if ever, used real physical force that you would think of. Nor did he, I don't think he really threatened serious physical force or violence. It was all a brutal manipulation because he was the powerful head of a movie studio, and he could wreck a person's career. He could blackball them from the profession. So that, I think, is totally legitimate. I think that is that should be in the definition of a rape in our society today. However, you will get experts. This expert, and I was very impressed by her. She was the expert in the famous Bill Cosby trial, which I did not do that trial. I did not represent Bill Cosby, but the expert who testified in the Bill Cosby case testified in a case that I had. And so I, obviously mastered her book and what I believe were the serious flaws in her book. But just to tell you, that type of an expert, I would leave it to you to question in connection. This may be an emergency. Excuse me. To use those examples of a Catholic priest using his authority, or Harvey Weinstein type character using his authority, I do think that is adequate to support a rape conviction. And I think that a person who does that probably should get the same punishment as a person who used actual violent force. But the point that I wanted to make about the experts, this lady who was in the Bill Cosby case, and by the way, I think Bill Cosby was accused of drugging the victims also. But this expert, and she has a PhD, very impressive, but I would ask you to compare these types of what is called here on her wheel chart, or pie chart of physical violence. This is using male privilege, treating her like a servant, making all the big decisions, acting like the, quote, master of the castle. And next category, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, not letting her know about or have access to the family income. And there's quite a few categories on this. Maybe some future we'll go through all of them, but I'll just give you one more. Using emotional abuse. So that is putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Now, an expert will come to court in certain situations and testify to the jury that, in the expert's opinion, the expert believes that that kind of conduct could also constitute the force of intellectual, moral, emotional, or psychological. And I, of course, would argue that that goes much too far. But there might be a certain rare situation that could occur that I might think that it was valid. But generally, I think that the wheel goes too far. I do very much respect this expert, though, from the Bill Cosby case. In the trial that she testified in, my client was found guilty, I think, of 29 out of 33 of the charges. There was one that I think was a little bit in this category, and that concerns me, and he certainly will appeal on that issue. But you do not, in answer to the first question, you do not have to threaten force or violence. And also, interestingly, that jury instruction has a little note that in a situation that sometimes comes up, it is possible under current law for a man to rape his wife. And I do think that that is legitimate, and that's a good thing if there would be a situation in which the wife really said, I don't want to do this, and through serious force, he forced her to submit to that. I do think that that should be a rape. This is not 100 years ago or the Middle Ages when a man was considered, or a woman was considered her husband's property. I mean, that's centuries ago. And so I think if there were force or violent force, or if there were some extreme emotional or psychological force, I could see a man raping his wife. I think he should be convicted if he did that. However, what comes to me, cases that come to me very often actually are situations where there is just trouble in the marriage, and the wife kind of uses the legal system as a weapon. And I'm not saying that that happens all the time, but it does happen. And you get cases where, if you know the full story, you know the full picture, you really have to question why the prosecutors would even allow cases like that probably belong in a divorce court. You sort of wonder why they would get into an actual felony charge in the criminal division of the court. But I do believe that there are situations where a husband could and does sometimes commit a rape of his wife. Now, this expert, and again, I respect her, but she would tell you that a woman could be raped and she would not even know that she had been raped, because she didn't understand the manipulations on the wheel that were being exercised against her. And then somehow this comes out, and she talks to a counselor, and the counselor refers her to somebody else. And sometimes these things do get tremendously blown out of proportion. Now, I said, what about a situation where, this is question 2, what about a situation where the alleged victim is a very promiscuous woman? And I say woman, but these charges apply to rape of men also. But if there's a situation, I think this comes up pretty often, a particular person, man or woman, is known as being very sexually promiscuous, and let's say that the person did have intimate relations with half the people in the workplace or half the people in the particular tavern in the town that everybody hung out at, or half the people in the dormitory. Now, we're not even thinking about a question of, does that just automatically shield you from a rape charge? Of course it does not. I mean, if a girl came to your dorm room and had sex with your roommate, that doesn't mean that she's consenting to have sex with you. But the question is, let's take that example. Would that past sexual history, you might say, or that other sexual event that that person engaged in, would that help your defense sort of to say, well, she is loose morally, she's promiscuous, she would consent with anybody, and she is not, in the old days they'd say she's unchaste. That would not even be permitted in the case. And there has been for years what is commonly known, lawyers have a technical name for it, but what's commonly known as the rape shield law. Now, there was a famous lawyer, sort of a generation and a half before my generation. So this is a ways back, probably 40 years ago. But I saw an interview with him. He was a nationally famous, extremely effective criminal defense lawyer. And he went on television and he said the experience of being cross-examined by me during a rape trial is more traumatic for the victim than was the actual rape. Now, can you imagine that? I mean, that is a horrible thing, but that's the way sex offense cases were 40 years ago. The last 25 years or so, we have had the Rape Shield law, and that is very strong. Judges will rarely allow an exception to this. There can be exceptions, and you would have to have a factual situation that it was so essential to your defense that it violated your constitutional rights to prohibit you from putting this evidence in. But what the Rape Shield law says is that the alleged victim's past sexual history cannot be presented during the trial, even if she had sex with every person in the workplace, every person in the tavern, every person in the dormitory. None of that is admissible. And I actually think that that is a fair thing. And it is problematic. And if you're defending the case, nobody likes that. The defense doesn't like it. But we have ways of dealing with it. It's not going to make a difference. We can deal with this. And if I get into it real deeply philosophically, I think that it probably is a matter of sort of philosophical evidentiary analysis. Would her past sexual history make her more likely to give consent to you in particular? And I'm not sure that even if we were allowed to prove it, to introduce evidence of that, I'm not sure that on a deep level that really would prove what we're trying to prove, that she was so promiscuous that she just automatically consented to have sex with you. So I really don't have a problem with the Rape Shield law, and if you and I happen to go to trial, we'll deal with that. But I do have a problem of recent amendments to the Rape Shield law. And that says not only can the defense is prohibited from talking about the alleged victim's past sexual history. Okay, so that's one thing. I can live with that. But the new version that came out just a few years ago, it says her past sexual victimizations or allegations of her past sexual victimizations. Now, what that means is if she cried wolf and said that somebody else raped her, that's not admissible. If she cried rape 100 times, if every boss she ever worked for in her entire career fired her and she then accused the boss of raping her, that's inadmissible. And I have a problem with that. And if I were doing your case, I would file a brief and a constitutional attack on that. The other two topics, I guess today we won't have time, but I'll tell you briefly. What about a situation where there is no medical evidence? And we discussed briefly the fourth question. What about a situation where there is no victim behavior that you would think that this victim acted, as this expert says, this victim acted predictably irrational? Let's talk about the medical evidence, because we talked a little bit about how we deal with the experts. But believe me, these experts, they're very impressive when they come into court and talk to the jury. But they are going to have their hands full on a day-long cross-examination trying to substantiate these theories. Now, as for the medical evidence, very, very often, there will be cases in which the alleged victim, and particularly if it's an underage victim, like if it was a girl, say 15 years old, if there is an allegation of a sexual assault, then that victim goes to the hospital, typically a children's hospital. And in the larger cities, they actually have what they call child advocacy centers, and they will supply the experts. But the first thing they do is a sexual assault examination. And a physician will perform part of that. And if there is no medical evidence, no contusions or abrasions, or no indication of damage to the hymenal membrane, that you would think, and that I can get doctors to come to court and say this rape simply didn't occur, because if this occurred, there would be medical evidence. But these medical experts are expensive, and whether you bring a medical expert of your own or not, the prosecution will bring a medical expert, and it will be a medical expert who is from the same culture of thinking as the behavior experts. And that expert will come to court and say, yes, it is possible for a grown man, 240 pounds, to have full penetration, vaginal sexual intercourse with a 15-year-old girl, and there be zero medical evidence. So at a future video, I will explain how we attack that. And that is based on a seriously scholarly, intellectually defective study, but a study that was published in the medical journals. It was published by a physician from a child advocacy center. And in a future video, I will explain exactly what the defect in that study is. But for now, I would leave you with, yes, if you're ever faced with this kind of a charge, the prosecution will call a medical expert who will say this to the jury. The expert will be very impressive, but I will destroy that expert on cross-examination. So that's all we have for today. I'm going to continue these videos about the most difficult cases to win. On my website, I have a video called How to Win Impossible to Win Cases. And I mentioned, I think there's a good handful of criminal defense lawyers and specialized criminal defense lawyers in Pennsylvania. I think they all have different talents. And I think my own talent might be that, winning impossible to win cases. But I guess all cases are a serious challenge. So that's all for today. I'll try to do some follow-up videos and explain some of these issues that we face. Thank you.